Good evening, members, and welcome to the second day of Gujarat RERA, where we will have eminent speakers all over India to guide us how to have a professional opportunity under the RERA regime. Today, we have an eminent faculty, Mithil Sampat ji, who will be taking on the Consumer Protection Act. Not taking much of your time, I request our coordinator Gautam to briefly introduce him. Before that, I would request our Vice Chairman, Drishti Desai Madam, to give her introduction of today.
Thank you, Vijayji, for this opportunity given for sharing my views. May I? Okay, so this is a great program. I think very specific on Gujarat RERA, and I'm sure members are greatly benefiting because of this program. So first of all, my heartiest thanks to all the faculties who have taken out their valuable time to be with us and educate the members. So that's a great thing. We have at WRC, we have been conducting all the programs on virtual platform from last more than 1 year. And because it is on virtual platform, all these programs are in recorded form. So anybody who wants to view them later can go on to the WRC YouTube channel and view it. And this is great resource for people for updating their knowledge, for training their office staff. So that's what we are doing on one hand. The other thing that we have started on WRC is also a portal by the name Coach. So that this is where women members have registered for employment, and they are available part-time, full-time, depending on their preference. And whoever wants to employ, depending on their profile, depending on their expertise, can register on the portal and look up the profiles and send out expression of interest to these members who are registered. So that's a completely free job portal that we are running on WRC platform. That's the other thing. We also have the help desk for charitable entities, which is on WRC platform. Now, this help desk was running excellent, but because of this IT portal issues, the help desk queries are basically only revolving around the IT portal related queries, and that's where I think it's come to stall. But otherwise, we have solved queries of more than 250 members on re-registration of charitable entities. And we have also started study groups on WRC at WRC. These study groups are also run on virtual platforms. So my request to members who are interested in the study groups which are run at WRC platform, they can register, they can still join these study groups. The new study groups that we have started this year are on direct tax, valuation, and indirect tax. Internal knowledge. Indirect tax was already there, and there are many other study groups. In fact, IBC study group is also running. So anybody who's interested, in joining these open platform discussions, can join this study group, and we'll have a meeting, one meeting every month, and all these study groups are working very, very efficiently. So these are some of the updates I thought I will share on this platform. And with this, I would hand it back to Vijayji for taking the proceedings further. Thank you.
Thank you, Drishti Madam, for sharing your views on the various updates what WRC is carrying out for its members. Now I request Gautam to briefly introduce our first speaker for the day.
Thank you, Vijayji. So our today's speaker is Advocate Mithil Sampat. So Advocate Mithil Sampat ji finished his BLSS LLB in the academic year 2015 and presently as a qualified professional. He specializes in the field of consumer law, real estate law, and cooperative society law, in which he has also published book alongside his father, Advocate. He has appeared and argued matters at various places like Supreme Court, Bombay High Court, Trial Court, Consumer Court, Real Estate Regulatory Authorities, Registrar of Cooperative Societies and Cooperative Courts. He has judged academic competitions in various colleges. He delivers lectures on consumer law, real estate law, and cooperative society law in MBA colleges, law colleges, and various other platforms. And he is also a faculty for various diploma programs. So with this brief introduction, over to you, Mithilji, for today's session.
My thanks for the introduction. Can we do share screen, please? I will share the PPT.
Sure, sir.
Yes, sir.
Can you see the screen?
Yes, sir, we can see it.
Can you see the PPT?
Yeah, we can see it,
Yes.
sir.
Okay. So my sincere thanks to WIRC and all the esteemed dignitaries and faculties, both present as well as in absentia. I have been given 45 minutes to discuss about the Consumer Protection Act, and in about 30 minutes I will take you through my PPT, and the remaining time we can tackle any questions. My dear friends, when allottees have a grievance against a builder, they have three options in front of them. They can choose one from RERA, IBC and consumer. Here, first of all, I must clarify that for one cause of action, you can only approach one court. For example, if you want refund, you cannot ask for one refund from RERA and second refund from consumer and third refund from IBC. No, that is not allowed. For each cause of action, you can approach only one court. And I will talk to you about pursuing your remedies under the Consumer Protection Act. In consumer law, there are two platforms where the allottee can approach. First, I will talk about the consumer courts, and then I will talk about this new authority called CCPA authority. So, CCPA is the consumer counterpart of the RERA authority. Before we even talk about consumer courts or CCPA, I will tell you some basics about the consumer law. In consumer law, promoter cannot file a case. Under consumer, promoter can only defend the court case, promoter can only appeal the order, and promoter can only execute the order. So in consumer law, only the allottee who qualifies as a consumer can pursue the action. So first you will have to determine and ascertain whether the allottee qualifies as a consumer. So question is raised, when am I not a consumer? And the answer is, you are not consumer if you are doing commercial purpose, but there is one peculiar exemption in that regard. See, having a commercial purpose is the opposite of being a consumer. Consumer means I am buying to enjoy or to consume, but commercial, it means I want to do some kind of profit with the property. So, if the builder can show some kind of message or email from the allottee that you want to give the flat on rent or you have purchased for some investment or for a resale. So, if the email reads, if the allottee has sent an email to the promoter saying, dear promoter, dear builder, my buyer or my tenant is getting anxious and impatient, please deliver possession. If builder can show this, this is commercial purpose. Another example is that please deliver possession fast. The ongoing rate is a very good rate and I want to sell and I want to get a good profit. So these are commercial purpose, and such kind of commercial purpose are generally not allowed when you want to rent and when you want to resale. But under consumer, certain types of commercial purpose is allowed. You have to show two things. You have to show self-employment and you have to show livelihood. Buying an office space, an office gala, it is commercial. But if you are yourself going to work there and that work is for your livelihood, it is allowed under consumer even though it is commercial. Now, normally what happens, many times we have already sent these messages and kept that I want to give on rent or I want to sell. So what happens in that case? If you have already sent email like that, does that mean you are stopped forever? No, you are allowed to have a bona fide change in intention, that when I sent email, I wanted to do resale or rent, but now I don't want to do that anymore. So even if you had such emails saying my buyer or my tenant, you can fix it. You can fix it by communication, subsequent emails, and you, in the court case, you can plead it by pleadings and affidavits. Just place it on record that you have had a bona fide change in intention, and now you don't want to sell or you don't want to rent and you want to occupy. Typically, allottees face some 16 type of issues. Possession is delayed, open parking is sold unlawfully, the amenities or the plans, they are changed or amended without consent, the carpet area is changed or some bogus areas are mentioned, advertisement is misleading, GUJRERA, RERA registration is not done, the permissions of the competent authority are not proper, encumbrances are not properly disclosed, society formation is deliberately being delayed, agreements are very arbitrary, one-sided, conveyance, the transfer of title is not being given, audited accounts are not being given, so money is collected but the grounds of appropriation is disputed. That is another example of grievance. Registered agreement is not being done despite collecting more than the prescribed amount, or the title of the land or the property is defective. So these are broadly the kind of issues that are faced by the allottees. All those issues can be tackled by the consumer courts. There is district, there is state, and then there is the national consumer court. My dear friends, the jurisdiction that is calculated and determined, that is as per the consideration which is paid, not the total consideration. So total flat can be rupees 5 crore, but if you have made only the first installment of 20 lakhs, it will go to district consumer court and not any other. Now, one more thing about jurisdiction. The territorial jurisdiction is a very new feature in this Consumer Act. You can file a consumer court case in your local residence or office jurisdiction. You have Ahmedabad residence or Ahmedabad office and the project is in Vadodara, many 6 hours away. You don't have to go to the Vadodara court. Your Ahmedabad court will pass an order for your Vadodara property. Consumer court allows you to do this. Now similarly, going a bit more far away, your residence or office is in Bengal, but your project is in Kerala. You don't need to go to Kerala under consumer court. You can file and argue in Bengal itself. Bengal will pass order for Kerala property. So this is a new feature of territorial jurisdiction in the consumer law, that you can file the case in your local residence or office jurisdiction. The general procedure of consumer courts is that the limitation is 2 years from the date of cause of action. Currently, because of coronavirus, this cause of action is put on hold. This limitation is put on hold. After filing, if you do not get admission hearing within 21 days, it is deemed to be admitted and your matter can move forward. When the summons are sent, the delivery or return will be recorded by the court. So summons are either delivered or it is returned back to sender. Builder has 45 days to reply from the date he has received. This 45-day limit is the maximum. Actually, this cannot be extended. Excuse me, sorry. This 45-day limit is actually the maximum and it cannot be extended. Supreme Court has come out with a ruling that 45 days is maximum. You cannot extend it even by condonation or delay. But because of COVID, again, this 45-day time limit has been put on hold. If builder appears in the matter, but he does not file reply, no written statement order will be passed, no WS order. So summons has been sent and delivered and he has come, but he has not filed within 45 days. So no WS order. And in another scenario, you have sent the summons, but he has not appeared itself. So ex parte order will be passed. The general procedure is that builder will file reply, there will be the evidence stage, and there will be written and oral arguments, and finally a decree will be passed. Now, whatever your type of grievance, like we saw, the consumer court has its own lens, own definitions, and own category of offences which it will use to determine whether there is any wrongdoing. The court will see if there is any deficiency in service. Deficiency in service, in short, means any shortcoming or inadequacy or even withholding information. Next, there is restrictive trade practice, and this is important. Restrictive trade practice means because of you, there has been a manipulation of the delivery or there has been some kind of cost escalation. So, for example, agreement is not registered on time and stamp duty burden has increased, or society formation and conveyance is being delayed. So, stamp duty burden has increased and the construction right, the construction potential, the FSI in the plot has increased, but you are not giving conveyance. So, that is all under restrictive trade practice, manipulating delivery or some kind of cost escalation. Another example of this, intentionally not selling the flats because right now rates are not good, so promoters are not selling flats. So they are not selling flats intentionally, so society formation, etc. is getting delayed. So the whole handover is getting delayed. These come under restrictive trade practice. Then there is unfair contract or one-sided contract, we can say. A contract which has terms which cause significant change in the rights of the consumers. So only the unfair terms and conditions will be void, not the whole contract. So anything unfair in your agreement, but even in your allotment letter, possession letter, conveyance deed, etc., any contract will qualify as unfair contract if it meets the criteria. They can even just send a letter, and if they have changed your rights, that letter will be an unfair contract and it will be set aside. The beautiful part of this unfair contract provision, any one allottee who obtains an unfair contract order from the consumer courts, say this collection is unfair contract, this cancellation is unfair contract, this extension of possession is unfair contract, the same clause will be null and void for all the contracts. All the allottees in the project can take the benefit. In fact, we can even go far and say that the unfair contract, things which have been set aside, which have been declared by the courts as unfair, you can use it even across projects. In X project, it has been held unfair, and Y project, same builder, different builder, doesn't matter. Y project, similar terms are there. So even Y project, unfair contract benefit can be taken. All projects, you can use one unfair contract order if the terms are similar. So what are the types of unfair contracts? Manifestly excessive security deposits for performance is unfair. For example, you pay the 2 lakh entire membership fees today, but the clubhouse or the gym will be functional after 2 years. Why should I pay membership if the thing is going to be functional after 2 years? So it is a manifestly excessive security deposit. Next, unreasonable money or obligations is imposed, which puts the consumer at a disadvantage. For example, if you do not reply within dash days, some 5-10 days, your money will stand forfeited. Such a thing can be unfair contract depending on facts of the case. Next, unilateral termination without any sufficient cause. If you do not reply within so and so days, the contract will be deemed to be terminated. Next, disproportionate penalty for breach. Now, what happens very regularly if you pick up the property agreements? Promoter will say, promoter's breach penalty is 9%, but purchaser's breach on payment 21% compounded interest. So why this disproportionate penalty? There have been cases where builders have been levied the higher of the penalty because courts have said that you yourself will pay less penalty, but you're making consumer allottee pay high penalty. So when allottee is succeeding in a case, the higher of the penalty has been levied upon the builder. Because this is a wrongdoing, builder has tried to put this higher on the consumer, so consumer courts have levied the same upon the builder. That is disproportionate penalty. Next, refusal to accept early repayment of debts. So for example, we had one matter going on. The builder refused the payment because the narration, the appropriation, we did not give it to him as per the way he wanted it. We had some dispute. We saw that he was charging us for the unsold inventory also. So refusal to accept early repayment of debts. He refused the payments on that ground. So that is unfair contract. Refusal to accept the early repayment. Next, permitting assignment of the contract to a third party. In this RERA and construction scenario, there are many joint ventures. There are partnerships, especially the contracts are not uploaded on the RERA websites. The RERA Act makes it very clear that there will be no third party transfer without the consent, and even consumer puts this clause in unfair contract. In the definition of unfair contract, it is said that permitting the assignment to a third party without consent of the consumer is unfair contract. So you can get heavy compensation when builder changes hands, when project changes hands, and you are not informed and your consent is not taken. Compensation can be claimed because it is unfair contract. One typical example of unfair contract was there in a judgment where it is stated like this: it is said that unreasonably short time of 10 days is granted to the allottee consumer. 10 days may you either agree to the 12-month delay or you take refund at 9%. So agree to 10 days, agree to the delay within 10 days, or after 10 days, if you don't agree, it will be forfeited. Your money will be forfeited. This was held as an unfair contract and it was set aside. Next is misleading advertisement. Marketing gimmicks are covered under misleading advertisement. Deliberately concealing important information is also covered. You can read the definition. The important thing about misleading advertisement, under section 89, there is punishment includes compulsory fine as well as compulsory imprisonment up to 2 years and 10 lakhs penalty. So you can imagine the risk of becoming a repeat offender. Under this clause, you have fine as well as imprisonment, and both are compulsory. In case of repeat offender of misleading advertisement, penalty increase. 10 lakh goes to 50 lakhs and 2 years goes to 5 years. And again, both are compulsory. So misleading advertisements are a very dangerous offense under consumer because there are strict provisions for punishment. And what is misleading advertisement? Amenities are advertised but they are not given. Carpet area is mentioned in the brochure advertisement, but different carpet area is given. Possession date is mentioned, but it is not given on that date. It is mentioned that permissions are there, asterisk, but OC and commencement certificate and other things are not there. So these are misleading advertisements. Builders can very easily fall into the trap of misleading advertisements under consumer. Also, it is important for you to realize that you can import RERA definitions of advertisement and prospectus into your consumer court case. You go ahead in your consumer court case and you plead that this brochure or newspaper advertisement, whatever, it qualifies not just as advertisement in consumer definition, but it is advertisement in RERA definition as well as prospectus in RERA definition. Next offense under consumer is violation of consumer rights. You can read the definition, but in short, bad construction means life of the consumer is at risk. So that is violation of consumer rights. The quality, standard, etc. of the construction materials, those have to be disclosed. Consumer awareness is made a right, which puts a very supplementary obligation upon the builder to make the compliance, to help the consumer whenever he is asking a question. Next offense and the last offense in consumer court is unfair trade practice. This has the largest definition and it is the most wide. You can read the unfair trade practice definition. The important aspects about this is false representations about the trait or quality, or even false representation about need. अरे ये ऐसा ये लगाना जरूरी है. This machinery is important or necessary. So wrongly they have told you that this is necessary, but it is not actually necessary. Unfair trade practice. So false representations, including false representation about the requirement or the need of any service or repair. So false representations and concealing. So flat is advertised as rupees X, but allotment letter shows slightly escalated. So that means bargain price has changed. So this is unfair trade practice. Now in unfair trade practice definition, it is given that every bill, every invoice for every payment, it has to be in the format prescribed by the rules. So in the format which is prescribed, you have to give the description of the particulars as well as the breakup of each of the things and including the tax. So like I said, we are having a case where he is charging us for unsold inventory, unsold flats, and we are pursuing that using this definition that you show us under which of the headers you are charging the client so and so rupees. My dear friends, technically speaking, these are all inclusive definitions. And in law, inclusive definition means that any new or novel type of wrongdoing cannot be dismissed on some frivolous technicality. Inclusive means interpretation of these definitions and offenses is very wide, very vast. So any new kind of thing, it is included. So these definitions are inclusive is a very, very important point. In consumer courts, like I said, you can use all the RERA definitions, So all the RERA definitions of disclosure and quarterly updates of false advertisement, possession, refund, alteration of plans, withdrawal from bank account, society formation, conveyance, transfer of title, all these substantive provisions which are defined in the RERA, all these provisions of RERA, you can pick up and you can put in the consumer court case by telling the consumer court that my lord, under so and so sections, he is supposed to comply. He is supposed to do disclosure under so and so section, but he has not done. He has done false advertisement under so and so of RERA and consumer, and that is the ground. He is not supposed to change the plans without consent, and this is the offense. So all the RERA sections you can import in your consumer court case. Coming to mediation in consumer courts, mediation can only be done with the consent of the parties, but mediation cannot be done in certain types of cases. In cases involving serious and specific allegations of fraud, impersonation, fabrication, forgery. So in about 30 to 40% of the real estate cases, there is some or the other kind of fabrication or fraud or forgery or coercion, or it is a serious offense. And mediation is not allowed in cases which involve public interest. In other words, numerous persons who are not parties before the court, if matter affects them, then you cannot do mediation. So for example, you have a whole project, all the allottees who are not part of your consumer court proceedings, they will be mediation cannot be done because it is prohibited. They will be affected by the mediation proceedings, and so it affects a large group of people. So you, when builder tries to say in consumer courts that you move for mediation, you downright refuse. You tell them that there is a public interest, there is a large number of persons involved, there are many other allottees in the project. Many times you have different phases of the project, and you have a layout, or there is a federation. So you tell the court, no, this is not allowed, mediation is not allowed, and you refuse. If builder tries to stall the proceedings by mediation. So large number of people are involved, mediation is not allowed. Then there is one mediation rule which is likely to be abused. One rule 6 of the mediation rule says that parties shall not initiate any arbitral or judicial proceedings in respect of the matter which is being mediated. In other words, if you have done mediation in consumer court, you cannot file any arbitral or any other judicial proceedings. This is one more reason. Do not go for mediation in consumer courts. Builder will say that you have done mediation, so now you are not allowed to file any other complaint. Many times you are fighting at different fronts, RERA, BMC or the corporation, criminal courts. Builder will try to manipulate, so you refuse mediation. Lastly, important about mediation, even if you do go for mediation, it is important that if settlement agreement, if you have finalized your settlement, if it is signed, then death of the party does not discharge the settlement. Parties still have to comply. Legal representatives of the party have to comply even though the main party has deceased. Now the consumer court has very, very strong power during the court case. If it is alleged that there is inferior construction of the inferior materials, testing of the material can be done at the laboratory. Consumer courts can summon any third party to give evidence, to give testimony, or to give information, or to give documents, including government authorities. Consumer courts have the power, they can call any person who is a private citizen or any government official. Consumer court can say, you come to the court and you answer why things are like this. You give evidence and you give testimony and you give information, consumer courts can say. In addition to that, consumer courts can even do raids, search and seizure it can do to protect the evidence. Now, when it is doing search and seizure to the investigation to see what is the evidence that exists, if it is found that some parties are destroying the evidence or there is a risk of destruction, that manipulation or evidence tampering, consumer court can confiscate the item in the search and seizure. When it confiscates, it can decide, okay, I have seized it, I will make a copy or I will do whatever information I want. Consumer court then has the option, do I return it or do I not return it? Consumer court has the option to confiscate it and keep it. Next power of the consumer courts, it can also, it can search any physical evidence, it can search any physical investigation. say financial records or anything. But more dangerously, it can even do digital raid or cyber forensics. Consumer courts can call electronic service provider. This term means any technology which enables sale. They can be called to the court to determine the correct facts of the case. Was any such advertisement put up and then taken down? Any information was changed? So in addition to the e-commerce provisions, this electronic service provider of the consumer courts, it makes for a very dangerous transparency in physical things as well as digital things. So people can be summoned, physical investigation can be done, and digital investigation can be done. Sorry, excuse me. In consumer courts, you can file two types of execution proceedings and you can file them simultaneously. One is civil and one is criminal. Under civil, you can do two things. First, attachment and sale of assets to pay the debt under your decree. Assets of the builder will be attached, they will be done auction sale. Proceeds from this auction sale will come to pay your debt under the decree. This is the first mode of civil execution. Second, execution of deeds. So when the consumer court orders, you enter into agreement of sale, you execute cancellation deed, you execute conveyance deed, and builder is not compliant. So what can we do in execution? In execution, you submit a draft of the deed to the court and court will execute it on behalf of the defaulting party. So this is civil execution. Your money will come after auction sale and deeds will be executed by the court. Under criminal execution, there is imprisonment, compulsory 1 month minimum up to 3 years, and there is also fine. In consumer court criminal executions, almost always consumer courts give 1 month imprisonment. This is the very least, and many times they give it. The risk of becoming a habitual offender under consumer is very high. We saw that misleading advertisement, there is compulsory fine and imprisonment, and if there is criminal execution, one more way to become a repeat offender. In some time, I will tell you about the CCPA authority, but talking about repeat offender, CCPA orders which are not complied, imprisonment is there also. So consumer court orders not complied, imprisonment is there. Misleading advertisement, imprisonment is there, and CCPA orders not complied, imprisonment is there. So you can imagine the risk of imprisonment and habitual offender. It is so high under the Consumer Act. When allottees fight, many times they fight in groups. They can fight at several platforms. One people go to criminal, one go to CCPA, one go to consumer court, and one go to RERA. All these different platforms can be gone to for getting hearings. And under consumer court, I told you there are many ways of becoming a repeated offender. So under consumer court, execution hearings finish very quickly. Civil execution does not even take more than 1 or 2 hearings. The recovery certificate is issued in 1 or 2 hearings. And under criminal execution, it is very strict and very serious. Costs are imposed and non-bailable warrants are issued if the opposite party is not attending. Frivolous adjournments are not given in criminal execution. The court upholds the technicality of a criminal trial. In consumer courts, most appeals are within 30 days. But if your complaint is in district commission, you have 45 days to appeal to state. And further, if you want to challenge district complaint, 45 days ke baad state, and then again state you want to challenge, you can go from state to national in such a scenario only on a point of law. So appeals are thought to be curtailed and prevented. So unnecessary appeal should not be there. Appellant has to deposit 50% of the decretal amount, and consumer courts can review their own orders. So now question is, what is the scope for chartered accountants in consumer law? See, under the old Consumer Act, there was a restriction, but under new Consumer Act, there does not seem to be a restriction. I will tell you. Mumbai consumer courts, there are NGOs like Mumbai Grahak Panchayat. So NGO can be started by applying to the Bureau of Indian Standards, BIS. So like I said, under old act, there was a disqualification that only advocate is allowed to use this NGO for livelihood and others cannot use. But under this new consumer, so far, this disqualification is not there. So as it stands today, CAs can form an NGO and they can argue in consumer courts. Now, till now I spoke about consumer courts. Now I will come to the CCPA authority. Just how RERA is the regulator for real estate, CCPA is the regulator for the consumer. RERA passes circulars from time to time, and even CCPA can pass circulars to tackle violation of consumer rights, unfair trade practice, and misleading advertisements. CCPA can also file a case in the consumer courts on behalf of the consumers. But the main job of the CCPA is to do investigation and to pass penalties. And CCPA protects consumers as a class, the class of allottees in a project or a class of allottees in the real estate sector. To do investigation, a designated investigation wing is given to eliminate the need to go to police. The CCPA has given its own police, an investigation wing. CCPA has the power to carry out raid, which means search and seizure. They can summon anyone to give information or evidence, and they have sufficient powers to tackle the investigation. They have sufficient powers to see if anything is going on which constitutes violation of the consumer laws. After investigation, a type of penalty is levied. Either Section 20 or Section 21 orders or both can be passed. CCPA orders are like a PIL, a public interest litigation to protect the class of consumers. Section 20 orders are very important. They are practically anything orders. Anything can be done under Section 20. Because the words of Section 20 are, the CCPA can pass such order as it deems fit. Anyhow it wants to tackle the wrongdoing, it has the flexibility without any straitjacket formula. So do not underestimate Section 20 orders. Examples are given in the section that large-scale orders can be passed, like large-scale mass recall, large-scale reimbursement, discontinue the unfair trade practice. So stop the delay in society formation or conveyance, protect the class of consumer, any type of order it wants, it can pass. Then Section 21 orders are exclusively for misleading advertisement. I must say that misleading advertisement, I told you, is tackled very seriously. I told you how Section 89 has those penalties. So in addition to Section 89, even Section 21 has very heavy penalties for misleading advertisement. It has money punishments, monetary punishments, which once again go up to 50 lakhs. It can also pass orders saying discontinue all advertisements on this project for up to 3 years while investigation is going on. And even 10 lakh penalty it can levy when investigation is still ongoing. It can say we have prima facie reason to believe, pending investigation 10 lakhs penalty is being levied on the promoter. So Section 21, very vast penalties, many types of penalties, monetary, stop advertising, etc. It applies to everyone, trader, manufacturer, endorser, everyone. We have read in newspapers that celebrities will be punished under consumer law if false claims are there. So this is under this Section 21. Anyone can be punished under false and misleading. No one can take a loophole that I was not involved or like this or like that. No, nothing doing. 21 is very vast. Anyone who is doing wrong advertisement will be punished. So including broker websites or startups, nobroker.com, magicbricks.com, even celebrities, whoever is endorsing the service, anyone advertising, they can be brought in the Section 21. Section 21 orders are something like this, that the bigger the wrongdoing, the bigger the wrong advertisement, the bigger the penalty. Because Section 21 gives express factors to be taken into account. Size of population has to be taken into account. Like there's a large layout with 600 flats and wrong advertisement was done on so many people. Size of population impacted. Another factor, frequency and duration of advertisement. All the phases were being constructed from 4 to 8 years. Amenities and advertisements have been fooling for so many years. Frequency and duration will be taken into consideration. What was the vulnerability of the people affected? Like taking advantage of the people who have already taken possession. Sometimes ignorant people or lesser literate, lesser educated. So in some poverty scheme construction is there and some wrong advertisement is done to what is the vulnerability of the people? They were slightly lesser educated, or because of the facts of the case, sometimes possession is given and they are in the lesser weaker position, or vice versa, possession is not given and they are in the weaker section. What is the vulnerability will be determined. And lastly, what is the gross revenue earned by the advertisement? Gross, not net, and revenue, not profit. Keep that in mind. So, to section 21 orders, the larger the wrongdoing, the larger the section 21 penalty. Now, to protect the promoters, these section 20 and 21 orders, they have certain safeguards to protect the promoter. Promoters have a right to be heard before the order is passed. That is the audi alteram partem rule of law. Order will not be passed without your involvement. Then there is another express defense. There are certain express defenses which you can take, which are given in the section. And there is also a vexatious search provision. Government CCPA is doing 2021 investigation on you despite knowing that you have not done any wrongdoing. Promoter can do vexatious search, that I want to sue the government, penalize the government. The officer, there will be jail or fine because he has done a vexatious search. Whoever, so this section 20 or 21 orders, you have to either comply or you have to challenge. You can challenge it to the National Commission within 30 days. Both these 20 and 21 orders, within 30 days, you can challenge. But if promoter neither complies nor challenge, he does not appeal and does not comply, CCPA can do execution against these people. CCPA will file an execution court case with the magistrate, who can, in addition to the existing penalties, further penalty of up to 20 lakhs fine or up to 6 months imprisonment or both can be granted. So CCPA can also file execution provisions with the magistrate. Just imagine, my dear friends, how many ways of becoming repeat offender is there under the Consumer Act, and repeat offender means the subsequently higher punishment will be imposed upon him. Generally, the defenses taken by the builders are that approvals and permissions were not issued, or that the occupants have done some kind of illegal or unauthorized construction. Force majeure is sometimes involved. General market scenario defenses taken that market is down. Consumer court will look at the facts of the case, and only when allottee is at fault, builder will be given that defense. All other reasons for delay are rejected. So in Mumbai, Maharashtra, there was a construction ban for some time. So court said that since it is banned, you are supposed to give refund. You cannot claim that from the allottees. So case to case basis, it is observed, and builder is allowed that defense only if allottee is at fault. Now, my dear friends, in general, you can file a court case against the builder and against your society also. You can file your court case, consumer court case, even only against society. Deviating from the RERA point of view, you can file a court case against your society because you are a member of society. It is well settled now that member of society is a consumer against the society. So, society NOCs are not given on time, parking issues are there, structural audit, financial audit is not being done on time, unauthorized construction not being acted upon, elections are not being done on time. For all society issues, you can file a consumer court case to fix the situation, or at the very least, you get compensation. Do not underestimate the compensation component under the consumer code. Maharashtra compensation in Maharashtra, slightly less it is there, 20,000 max or 40,000 max. Consumer code, if there are many causes of action and offences, compensation in the lakhs is given, whether the case is against the society or against the builder. So keep in mind, friends, that you can do a consumer court case even against the society. And so you can do against society, you have some society issues, or other times society is hand in glove with the builder. Deliberately committee members are hand in glove with the builder. So in such a case, you can file a consumer court case against both. Under the same roof, you can tackle out all your grievances against all the parties. Question is raised, can I file the similar this thing against society and builder in RERA? If your RERA rules do not support it, and if you have to file in different courts for the relief, you come to consumer, dump everything under one roof. In Maharashtra, when these cooperative registrars, these cooperative society registrars are there, when they pass orders, they do not have the authority to grant compensation. So you get a registrar order, or even if you don't get registrar order, you show these wrongdoing sections to the consumer court that under so-and-so section society was supposed to do it, get compensation. Many times, even when registrar passes order, society does not comply. Take that order, take that society to the consumer court, say that so-and-so order has been passed, but they are not complying. Even registrar does not have execution powers that much. So, consumer court case file, that order is passed and they are not complying. You will be surprised how much compensation you get. And in registrar order cases, you can also file for compliance. That order is passed, they are not complying. Consumer complaint, prayer, please comply. So like that also for compliance and compensation you can file. So my dear friends, I'm nearing the end of my PPT. I will summarize the strengths of the Consumer Protection Act for you. First of all, they are all inclusive definitions. So they have a very wide import to protect the allottee. And plus you can use the substantive provisions of RERA also. So these inclusive definitions do not underestimate. Second, you have local territorial jurisdiction where your local residence or office is there. Then you can claim stamp duty and cost escalation from the consumer courts, which I am yet to see from RERA, that deliberately, now see, RERA prescribes the time limit for handover. When it is not handed over in that period, you can tell the court that cost escalation from that date. You claim it from the consumer court. You show the working out that on X date it was supposed to be handed over. It was handed over, say 1 year later on Y date. The rates of stamp duty, etc. On X date it was so and so rate, and on Y date it is the escalated. Claim the cost escalation in consumer courts. I am yet to see a RERA order like that. Then unfair contract provisions will tackle a lot of the wrongdoings in the transaction, including without consent, joint ventures, and any arbitrariness, any bullying, any one-sided behavior of the promoter, you tackle with unfair contract. Any manipulative clauses, any wrongdoing which is doing one-sided, this unfair contract will cover it. Then one unfair contract order will have implications in the whole project and in the whole sector really. So do not underestimate unfair contract order of the consumer courts. Then amenities, brochure, advertisements, the compensation, they are literally at today's standard of living levels. So these compensation 20 lakhs, 50 lakhs, promoters should be very afraid of doing the wrong things because the penalties are so high. They are in lakhs of rupees. So builders have to be very careful about the statements that they make in the brochure and the advertisement. Continuing the strengths of the Consumer Act, people can be summoned to the consumer courts and to the CCPA. Then CCPA consumer courts, they can do raids, they can do search and seizure, which I have seen newspaper reports. I have seen that Gujarat RERA has done forensic audits. So similarly, consumer courts can do physical raid or digital raid, search and seizure. Then under consumer, very easy to become repeat offender. Consumer court orders non-compliance, criminal provisions are there which are very strong. CCPA can pass penalty even when investigation is ongoing, and on top of that CCPA can also put for execution. Misleading advertisement, compulsory penalties are there. Monetary penalties are also very high. Important thing, arbitration clause will not prevent your consumer complaint. RERA may be inclined to say that there is arbitration clause, so you go for arbitration mediation. Under consumer court, even if there is arbitration clause, you cannot be forced to go for arbitration. Consumer court, you can file a case despite the existence of an arbitration clause. It will not be prevented. You can ignore the arbitration clause. Then under consumer, when allottees file at different platforms. One side go to criminal, one side go to consumer CCPA, one side go to consumer court. one set go to RERA. Spread out your fight. And to conclude, my dear friends, let me say RERA Act is a central law, but the RERA Act is only and only 30% of the total law. States are responsible for remaining 70% for the rules, regulations, circulars, etc. The states are responsible. Updating the law, updating the market scenario and bringing the law level with the market scenario, RERA is responsible. So RERA is responsible for 70%. The states are responsible for 70% of the law and 100% of the implementation to update the law to the prevailing industry requirements. So state is responsible for 70% of the law and 100% of the implementation. My dear friends, consumer has provisions like electronic service provider, digital rate, wrong advertisement, and if state RERA can also pass such orders, like I said, forensic audit is ordered by Gujarat RERA. So state RERA can also pass such kind of orders that carry out investigation, wrong advertisement other come down heavily. So there will be no need to go to the consumer if the RERA authorities are so proactive and if it's finished off in a time-bound manner. I have read in newspaper reports that 99% of the cases in Gujarat RERA, they are settled. So the purpose of the law seems to be achieved. And if there is any case of dispute, matter has to be heard and litigated, let the RERA carry out investigation in the same way that consumer does. So, and powers are there with RERA. Don't worry about that. There is enough statutory backing for RERA to carry out such a kind of investigation. If these powers RERA also exercises, then there is not much need to go to the consumer, and people will be very happy by the time-bound adjudication of RERA, especially Gujarat RERA. So with that, my dear friends, I have come to the end of my PPT. We can take any questions if there are there.
Yeah, I think there are no questions right till now.
I'm sorry?
There are no questions as of now.
No problem.
Okay, since there are no questions, thanks Mithil bhai for such a wonderful session.
My pleasure.
Where you have taken us through the Consumer Protection Act. You have explained to us what is meant by commercial purpose, what are the issues faced, what are the jurisdiction of consumer commissioners, what are the offences under CPA, unfair trade practices, what are the mediations, and what are the various scopes for chartered accountant in this area. Sir, we are indeed thankful to you for accepting our invitation. Your presentation was very excellent, and you have spent your valuable time so that we can enrich from your knowledge. So on behalf of WIRC, I propose a well-deserved vote of thanks and request all the members to carry out with a virtual applause. Thank you, sir.
My pleasure. My pleasure. I am grateful for WIRC inviting me. The pleasure is absolutely mine, sir.
Thank you, sir. Okay, now moving further. In the second session, we are on the topic of offences and penalty, which will be taken by CA Mohit. Now, not taking much of your time, I will just briefly introduce him. He is member of the institute since 2009. He is a BCom FCA CFA level 3 candidate. He is also an insolvency professional registered with IBBI and also successfully completed certificate courses conducted by the ICA on concurrent audit of banks. He is a practicing chartered accountant in Junagadh in the field of RERA, insolvency, corporate law, direct tax, and indirect taxes. He is carrying more than 12 years of experience, including working in Dubai at various managerial positions in real estate industry. He has delivered lectures at CREDI on RERA awareness program in Junagadh. He was the member of RERA study group and task force formed by CECL and EL of ICI in the year 2018-19. He was the founder convener of Junagadh CP study chapter of WIRC and served the chapter from 2017 to 2019. Brief introduction, I introduce before you CA Mohit. Sir, you can start your session right now.
Thank you, Vijayji, for the kind introduction. First of all, I would like to thank WIRC and all committee members of WIRC, Chairman Sir, Vice Chairman Madam, and all the members for giving me an opportunity to talk on this novel subject, which is RERA, more specifically Gujarat RERA. Vijayji, is my screen visible to you?
Yeah, it's visible, sir.
Okay. Okay. So topic basically given to me is offenses and penalties under RERA. Uh, to understand what is offense in a single meaning, we can simple meaning we can say offense means something which is unlawful, which is not right, means which is wrong. If anyone, any stakeholder under RERA is doing something wrong, then he will be punished with the penalties. So there are provisions for the penalties, and there are provisions for the offenses for which the penalties will be levied. There are these basically 12 sections which are dealing with the penalties. These are the penalties which can be imposed on the promoter, agent, and allottee for contravention of any of the act, rule, regulation, any of the order of the or direction of the authority or tribunal. Now, to understand what is wrong, we need to understand what is right. So basically, this is the second day of the refresher course. In the forthcoming session also, you will be seeing, you will be going through the entire act. But just to make you understand what is right, you will be able to understand what is wrong, and then you can be understood that if something is wrong, what are the penalties. I will try to just touch upon a basic sections. So first of all, these are the provisions of the penalties and offenses from 59 to 70. The ones which are highlighted in yellow are the ones which can be imposed on the promoter. The ones which are highlighted with blue are the provisions which can be imposed on the agent, and the ones which are in pink are the penalties provisions which can be imposed for violation of any of the provision of the law to the allottees. And last two sections are in kind of general sections. So now, as I said earlier, we will first go through briefly go through the entire act, and we will try to touch upon the minor things where something could go wrong by the promoter, or maybe by the agent, or by the allottee. Friends, the entire RERA Act is spread over 10 chapters covering 92 sections. It is a 37-page legislature. Now, if you see chapter 1, it talks about preliminary sections, basically short title and definitions. The main sections are lying under chapter 2 and chapter 3, basically which are relating to the promoters. Section 3 is about registration, which talks about no promoter shall book, market, advertise, sell, take booking, or invite any person to purchase any property, any property, any plot, apartment, or building, as the case may be, in any of the real estate project without registering the project with the regulatory authority. So this is the main provision, and I think so far majority of the orders are under section 3 and section 4. So this is the section where promoter could go wrong without first taking the registration of the real estate project. Promoter tend to advertise their project earlier. When the act came into effect in 1st May 2017, Central Act came into picture in 2016, but after 1 year Gujarat RERA came into the picture. So earlier they used to do the advertisements in the newspapers without taking the registration, and RERA authority used to take the copy of those newspapers and see that if there are no registration number and the RERA website address is not mentioned, they used to charge penalties on the promoter. But now, to a certain extent, to a greater extent, I may say, to a greater extent, these kind of advertisement are not there, where you can see the advertisement or website address. The fourth section is application for registration of real estate projects. Now, in this section, there are certain these things. documents which are required to be furnished to the authority while making the applications. If any promoter is making any false documentation, if any documents is furnished which is not true, then there will be a penalty for that. Further, this section 4 subsection 2 clause L and subclause D, it says that 70% of the amount collected from the authority should be deposited in the RERA retention account and should be withdrawn as per the progress of the work. It also says that at the end of the financial year, the promoter has to get its accounts audited, RERA audit, RERA certification in Form 5. It needs to be done within 6 months of the end of the financial year. So these are the requirements which are mentioned in section 4. So if any of the violations are there of section 4, there will be a penalty for that. Then grant of registration is obligation on the part of the authority. Extension is again obligation on the part of authority. Revocation of registration, if there is a revocation, what could be the scenarios? Then obligation of the authority consequent upon lapse of revocation. This is again not a burden on the promoter. Registration of, then the section 9 and section 10 are mainly dealing with the agents. So if any agent is acting as an agent in the real estate project in any of the locations in the Gujarat, and if he is not getting himself registered, what are the penalties? We will look into it. Then if a real estate agent has to function as per the provisions of section 10, and if there are anything which, you know, any kind of facilitation thing which is not done as per the act, then he may be subject to penalties upon the complaint by the allotee, or maybe on a suo motu basis by the authority. So this is the particular about chapter 2. Chapter 3, it is dealing with mainly functions and duties of promoter. So section 11 is also very important, where, you know, the promoter has been given a responsibility to file quarterly return on a regular basis. So after getting the registration, if promoter is not getting quarterly return filed on a regular basis, then it is a violation of section 11. Then the section number 12 is obligation of the promoter regarding the veracity of the advertisement and prospectus. Sometimes it happens that what is shown in the browser is not exactly given to the allottees. So if there is anything which has been made as a statement or as by way of any pictorial representation in the browser or any kind of advertisement, and on the basis of which allottee has relied upon and has taken the particular unit, and afterwards the whatever was promised has not been provided, then there is a violation of section 12. Then section 13 is about deposits to be taken by the promoter from the allottee, and it has to be done by way of registered agreement for sale if the amount of amount of advance is more than 10% of the total value of the unit. So if any promoter is taking more than 10% of the amount without entering into the registered sale agreement, then he is also subject to penalty. Then section number 14 is about the alteration. If any promoter is trying to alter the plan, then he has to take the permission from the 2/3 of the allottees. If there is a major alteration, if there is a structural alteration in the plan after it has been booked by the allottee, then he has to take the permission from the 2/3 of the allottees, and then only he can apply to the alteration to the Gujarat RERA authority, and then he can get the altered registration. But before that, if he is altering the things and which is not as per approved building plan, and he has not taken the consent of the 2/3 of the allottees, then he also is subject to penalties. Then section 15 is about the obligation of the promoter in case of transfer of real estate project. If there are any issues in the transfer to the third party, then also he will be subject to some troubles. Then he has to take some insurance. And section 17 is about transfer of title. We will discuss more about transfer of title in the tomorrow's session. But if there is any deficiency in the transfer of title, including the transfer of common areas to the association of allottees, then also will be subject to penalty and offense. It will be considered as an offense which is unlawful, and then they will be subject to penalties against that particular offense. Then section 18 is talking about the return of amount and compensation if any allotee is not satisfied with the quality of the work, or maybe there is any delay in the possession of the unit, then the allotee can file a complaint against the promoter for the return of the amount and also the compensation along with the interest. Then section so far this is chapter 1 and chapter 2 and chapter 3, which are more relevant for our today's topic. Rights and duties of allotees under chapter 4 are exactly opposite to the duties of the promoter, so we will not deeply go into it. Then chapter 5 is about 20 to 40, section 20 to 40 are about the functions and powers of the RERA authority. Section 41 and 42 in chapter 6 are talking about the centralized advisory council. Chapter 7 is about the appellate authority, which is covering section 43 to 58. 59 to 72 we are already covering. Then section 73 and 70 to 78, chapter number 9, we'll talk about the finance accounts and audit reports of the authority, so which are not more relevant to our today's topic, and miscellaneous sections are there. So basically, as I discussed earlier, the chapter number 2 and chapter number 3 will be more relevant for our today's topic. So far you might have understood that what is lawful, and now we will go to if something is unlawful, what are the consequences. I'll again go to my previous slide. So first we'll discuss about the penalties to be imposed on the promoter. So there are total 5 sections. So we'll briefly discuss those sections. The first section is section 59 subsection 1, which is saying that if any promoter contravenes the provision for registration of real estate project, then the penalty is up to 10% of the estimated cost of the project. So if any promoter is doing a marketing activity, advertisement activity, is printing brochure and he is handing over the brochure to the people, and he is doing advertisement on the social media or on the by way of banner or any medium, if he is doing that, and if it has come to the notice of the RERA authority, or maybe someone allotee or someone has filed a complaint against it, then he may be then, or otherwise RERA authority can take assume action on him. And then RERA authority has the power to impose a penalty up to 10% of the estimated cost of the project. Then we will go to section number 59, subsection number 2. This section is saying that if promoter is doing this thing repetitively, I mean after the things has been came to the notice of the RERA authority, and RERA authority has given some orders to the promoter, and if he is not complying with those orders or decisions or direction issued by the registration authority, and if he continues the violation of the provision of the registration, he is not getting the registration done for his real estate project, then he may be subject to 3 years imprisonment. He can be, RERA authority has power to impose imprisonment up to 3 years, and he can can be heavy penalty of further additional 10% penalty of the estimated cost of the project, or he can be subject to both of them. So he can be imprisoned up to 3 years, he can be charged further 10% of the estimated cost of the project, or both. Now if you see, the last column I have mentioned in my presentation is about the compounding of offenses under section 70 read through 19. We'll have a separate slide for these compounding offenses, but I have covered here so that you can know that wherever there is a word imprisonment is used, there will always be a compounding of that imprisonment. And for this particular 59.2, whenever there is an imprisonment, it can be done away with subject to certain terms and conditions as mentioned in rule number 19. But yes, there is a compounding by way of 5% of the estimated cost of the project. So we have seen section 59(1) and 2, which are more relevant to section 3, which is about the registration. Now we'll move forward to section number 60, which is for the purpose of violation of section 4. If there is any violation of section 4, then penalty under section 60 will be applicable. These penalties are if any promoter provides false information, as I mentioned earlier, that section 4 is all about making an application furnishing the information to the Gujarat authority. So if any promoter is providing information which is not true, it means which is false, then he can be subject to penalty up to the 5% of the estimated cost of the project. Also, if any of the provision of the section 4, that means main section is 4.2 LD, as I mentioned earlier. Section 4 subsection 2 clause L subclause D, which is talking about depositing the 70% of amount collected from the royalties to separate RERA designated account and withdrawing the amount as per the progress of the work based on the certificates received from architect, engineers, and chartered accountant. So in chartered accountant certificate form 3, there will be amount which is incurred and paid till date, which will be allowed to be withdrawn by the promoter. So if any promoter is withdrawing the amount which is more than the limit prescribed under form 3 CA certificate given by the chartered accountant, then also he is in trouble, and up to 5% of the estimated cost of the project can be levied as a penalty. So section 59 and section 60 is covering section 3 and section 4. Now this section 61 in column of section violated, I have mentioned others. So I try to briefly touch upon the other provisions of the act. So other than section 3 and section 4, whatever other sections are there, if there is any violation of any of the other sections, for example, he is not taking the approval of 2/3 of the allottees and he is altering the plan after it has been registered, and then he will be subject to penalty. If he has given something else other than what is mentioned in the brochure, then there is a violation of section 12, veracity of the advertisement. If he has taken more than 10% of the amount without getting the registered agreement for sale, then again he is violating section 13. So all other sections other than section 3 and 4, whatever violation he is doing, then he may be a subject matter of penalty under particularly this section 61. So if you are practicing chartered accountant and if you are practicing in RERA, you might see quarterly return default notices or annual return, that means form 5 default notices. You might be looking at the judgments. It will always have a reference of section 61 because it is for the others. So if he is not filing quarterly return, that means he is not abiding by the duties mentioned in section 11. So if he is not abiding by the duties mentioned under section 11, it will be covered under these penalty sections and he will be charged a penalty under section 61. So under all these sections, he will be it can be imposed a penalty of up to 5% of the estimated cost of the project. So till now we have seen all the violations of the act rules regulation. Now we will see section 63 and 64, which is particularly talking about any of the directions or orders given by the authority to the promoter. So if any promoter who is not abiding by the order or direction of the Gujarat RERA authority, he shall be liable to penalty on a daily basis. He will be liable to, for a penalty, there will be a penalty imposed. So far I have not seen such kind of order where there will be a daily basis of penalty issued by the authority. But yes, Gujarat RERA authority has power to impose penalty on a daily basis, and that penalty can be any amount which is determined by the authority in the order, but total amount of the cumulative amount of the authority should not exceed the 5% of the estimated cost of the project. Similar way, section 64 has been framed in the Central Act, which is saying that if any promoter is failing to comply with or contravenes any of the order or decision of the or direction of the appellate tribunal, if any matter has went till the level of appellate tribunal, and if appellate tribunal has given some directions or decisions and orders to the promoter, and if promoter is not abiding to the particular directions, then again the FT imprisonment section is here. Earlier we have seen in section 59(2), where if the promoter has not registered his project and after repeated reminders, if he is not registering, then he can be subject to imprisonment. And here in section 64, when he is not abiding by the order of the appellate tribunal, then he can be subject to imprisonment of 2 to 3 years, or every day default which is happening after the order has been passed by the appellate tribunal, he will be charged daily penalty as per the order, and it could not exceed 10%. So up to 10% of the estimated cost of the project can be a penalty and monetary penalty and up to 3 years of imprisonment. Either of the two can happen, or both of them can happen to the promoter. So it is very important to note that if any directions of appellate tribunal are not followed, then the RERA authority has power to to charge hefty penalty as well as the imprisonment of the promoter. Again, as I mentioned earlier, in the compounding of offense under section last column, I have mentioned 5% of the estimated cost of the project. The word imprisonment, whenever there is a word imprisonment, there will be a consequent compounding of offense clause. So 5% of the estimated of the project cost it can be paid in lieu of imprisonment. So far, these are the sections which we have discussed about the promoter. Now we will move further to the agent. If any agent is not following or abiding by the provisions of the Act, rules and regulations, then he can be subject to a penalty of 10,000 rupees. To my surprise, in this particular sentence in the Act, it is mentioned he shall be imposed penalty of 10,000. It is not mentioned the word up to. So I don't know, but if there is any violation of section 9 or section 10 by agent, then 10,000 for every day of default, which is a very heavy penalty on the agent, can be imposed, and the cumulative amount which cannot be more than 5% of the estimated cost of the unit facilitated by him. So suppose if agent has been acting as an agent, if he has sold 5 flats of the promoter, and if anything is wrong in that particular flat, then the estimated cost pertaining to those 5 particular units and 5% of that estimated cost, maximum RERA authority has power to impose penalty on the agent. This is the only section in case of promoter. We have seen 59, 1 and 2, and section 60 and section 61. In this particular case of the agent, there is only one section, which is section 9, about the registration of the agent. If he is not getting himself as a registered agent with RERA authority and dealing in the real estate agent activities, and section 10 is about the functions of the agent. If he is not abiding by his duties and functions, then there will be penalty on the agent. Now 65 and 66 are similar to what we have seen in the earlier section for the promoter. That if the promoter is not abiding by the directions, orders of the authority, then he will be liable for daily penalties, and cumulative amount of the penalties should not exceed 5% of the estimated cost of the unit facilitated by him. Similarly, as we have seen in the promoter section, here also it is the same in section 66. If he is not abiding by order of the appellate tribunal, then order or decision or direction, then he can be subject to imprisonment of up to 1 year. There it was up to 3 years. Here in case of agent, he can be imprisonment up to 1 year, and he can be imposed the penalty on a daily basis, the cumulative amount of which cannot exceed 10% of the estimated cost of the unit facilitated by him, or with both. Again, as I mentioned earlier, the word imprisonment is there, so there will be always a compounding under section 70, read with rule 19, which is 5% of the estimated cost of unit facilitated by him. So far we have discussed about the promoter, agent, and now the next slide is section 67 and 68 about the allottees. Now, if you go through section 19 of the Act, which is about the duties of the allottees, there are some allottees are duty bound to pay the common maintenance, common electricity bills, other common expenses. Also, they are liable to pay to the promoter whatever amount has been agreed into the agreement for sale. So if any of the complaints are filed against the particular allottee, then if allottee fails to contravene any of the order, decision, and direction issued by the authority after hearing the parties, and if the allottee is not particularly following the directions of the Gujarat RERA authority, then Gujarat RERA authority has power to impose penalty on a daily basis or on a maybe monthly basis, because here it is mentioned for the period. In all other sections, it is mentioned for every day. Here it is mentioned for the period during which default continues. So it can be anything, any quantum of duration. And cumulative amount is again, cumulative amount of penalty shall not exceed the 5% of the estimated cost of the unit. So if he has taken a particular shop, or if he has taken a particular flat, the total amount of penalty on the LOT cannot exceed 5% of the particular cost of that particular unit. Then section 68 is about appellate tribunal. If any matter has went from authority to education officer to appellate tribunal, and if appellate tribunal has given any directions or any order to LOT, and if LOT fails to comply by those directions or orders, then again, if whenever there is a appellate tribunal, there is bound to be an imprisonment clause. So if there is any violation, then LOT can be subject to imprisonment up to 1 year. So in promoter, we have seen that he can be subject to imprisonment for 3 years. In agent, we have seen he can be subject to imprisonment up to 1 year, and in LOT also he can be subject to imprisonment up to 1 year. And the amount of penalty again on a cumulative basis, which could be up to the 10% of the estimated cost of particular unit which he has bought, or with both. And again, it is subject to compounding of offenses with 5% of the estimated cost of the unit. So far we have seen almost all sections. There are now 2 general sections which we'll briefly touch upon. Offenses by companies. When we read but this particular section and we go by the heading, we find it that okay, the promoter is partnership firm, this section will not be applicable. We might skip this particular section 69, but it is important to note that it is the explanation is given after the section, but in order to read it better, I have purposefully reiterated the explanation on the top, which is saying that company means any body corporate and includes firm, any other association of individuals, and director in relation to firm means a partner in the firm. So in case of partnership firm also, this particular section 69 will be applicable. In Gujarat, in major cases, you will find partnership firms. There are certain companies also, but in smaller towns, you will see that partners are combining for particular project. They are creating the partnership firm. They complete the project. The partnership firms get closed down, and again for new project there will be a different set of partners. So this particular section 69 will be applicable to those promoters also if there is any offense committed by the partnership firm. Section 69 subsection 1 is saying that where any offense has been undertaken, if where there is any offense under this act has been committed by the company or maybe partnership firm, we will interpret the company as partnership firm as well. Every person who at the time of offense was committed was in charge of or was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be the guilty of the offense and shall be liable to be proceeded against and punished accordingly. So any partner or any director of the firm or company will be can be subject to violation of this particular all the sections which we have seen 59 to 70. So RERA authority can drag partnership firm as well as partners under this particular section, provided that nothing contained. There is a first provision on this: provided that nothing contained in this subsection shall render any such person liable to any punishment under this act, if he proves that the offense was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offense. So if intention was proved that he was not involved in particular partner or director, then he may be out of this particular section. Now then it is saying that we have seen 69. 69 is basically saying that any partner or director will be also liable at par with the firm, because if you see, I have highlighted the word also be deemed to be guilty of. So the section 69 subsection 2 is using the word also. That means a partnership firm and all partners as well as company and all directors can be subject to the penalties. But so far we have seen in most of the orders, either a company or a partnership firm which is a promoter has been imposed the penalty, and there is no additional penalty imposed on the directors or partners of the company or firm. Now the last section, compounding of offenses. We have already seen the compounding offenses, and we already know that there are totally 4 kind of offenses where there is an imprisonment. We'll again look into it in the next slide. I'll just go through this section 70. Notwithstanding anything contained in the Code of Criminal Procedures 1973, if any person is punished with the imprisonment under this act, the punishment may either before or after the institution of the prosecution be compounded by the court on such terms and conditions and on payment of such sums as may be prescribed. So we already know that whenever the word prescribed has been used, there will always be some provision in the rule, Gujarat RERA general rules or any other rule of under Gujarat RERA. So we'll try to look into what are those rules which are prescribed with terms and condition and payment of such sum, where any kind of offense which is punishable with the imprisonment can be compounded. And there is a proviso in the section 70 which is saying that maximum amount of fine can be imposed is the one which is equivalent to the fine which can be imposed on a particular offense. Now we will see what is prescribed in the Gujarat RERA general rules. So in Gujarat RERA general rules 2017, there is a particular rule number 19, which is saying the terms and condition and the fine payable for compounding of offenses under section 70. If there is any offense which is punishable with the imprisonment, and then we have to refer to rule number 19 to see what are the terms and conditions subject to which the offense can be compounded. Section 9, rule number 19, sub rule 1 of Gujarat RERA general rule is saying that the court shall, for the purpose of compounding any offense specified under section 70, accept a sum of money as specified in below table. Table is almost similar to what we have seen in those particular slides, but I have just compiled all the imprisonment provision under one particular slide. We have already seen this, just the revision of what we have seen. Under 59.2, we have seen that if after repeated reminders of the registration, if promoter is not getting his project registered, then he can be subject to penal imprisonment of 2 to 3 years. Then in order to compound a particular offense, a court can accept a amount up to 5% of the estimated cost of the project. Similarly, section 64 is about violation of any of the orders or direction of the appellate tribunal by the promoter. Then in lieu of up to 3 years of imprisonment can be compounded by way of 5% of the estimated cost of the project. 66, we have seen agent not following the order, direction or contravening of the decision of the appellate tribunal, up to 1 year of imprisonment. It can be compounded by way of 5% of the estimated cost of the unit facilitated by the agent. Section 68, we have seen that if any LOT is not abiding by the order of the appellate tribunal, then he is subject to 1 year of imprisonment, and that particular offense can be compounded with by way of 5% of the estimated cost of the unit. Now, what are the terms and conditions subject to which a compounding of offenses can be granted? It is on the payment of sum of money in accordance with the table above. Any person in custody in connection with that offense shall be set at liberty, and no proceedings shall be instituted or continued against that person in any court. The acceptance of the sum of money for compounding of an offense should be in accordance with the table above by the court shall be deemed to be an amount in equital with the meaning of section 300 of the Code of Criminal Procedure 1973. The promoter, allotee, or real estate agent, as the case may be, shall comply with the order of the regulatory authority or the appellate tribunal for which he was charged, for violation of which he was charged the imprisonment. within the period specified by the court, which shall not be more than 30 days from the date of compounding of the offences. So within 30 days, he should make good all the offences which he has done, for which he was charged to the imprisonment. Now, so far we have discussed all about what is there in the Act, rules and regulations. This single slide, this last slide, this is just analysis of the penalties so far imposed by the Gujarat authority for the violation of Section 3. As I mentioned earlier, the major violations are Section 3 and 4, and in these 3 and 4 also, the most of the cases you find on the website are for the violation of Section 3, where you see the acceptance of booking by the promoter or maybe advertising by the promoter without first getting his project registered. So these are the top 5 cases which I picked up from the website, where the highest penalty so far for violation of Section 3 was of 50 lakhs, then 27.39 lakh, then 20 lakhs, then 18.36 lakhs, and then 17.29 lakhs. If we look into the order, in the order it is mentioned what was the estimated cost of the project. So against the penalty of 50 lakh, the estimated cost of the project was 174 crore. So roughly 0.3% of the penalty was charged for this particular judgment, as against the power given to the authority of 10%. In the initial phase of its implementation, there might be a liberal approach from the authority, but going forward, as we take the steps further and if we enter into the next phase, there may be a chances where there may be a hefty penalty which can be imposed on the promoter for the violation. So in the first project we see 0.3%, then in the second one we can see it is exactly 1% of the estimated cost of the project. In the third one we can see it is roughly 0.5%. In the fourth one 0.7%, and in the last order I could not find the estimated cost of the project on the order, but so far these are the main highest penalty imposed by the Gujarat RERA authority for violation of Section 3 under Section 59 subsection 1. So far this was the I think I have finished on time. Thank you very much for the session. Hello.
Yeah.
For the patient hearing.
Thanks, Mohit. I think there are no questions till now from the participants. That means they had understood whatever you thought. No, they had understood.
Maybe.
Okay. So Mohit, we are indeed thankful to you for taking us through what are the various offences and penalties which are under the Gujarat RERA, whereas you have explained us the preamble to the Gujarat RERA, the penalties which are levied under Section 59 to 70, what are the penalties which are applicable to the promoters, the real estate agents, etc. We are indeed thankful to you for accepting our invitation. Your presentation was excellent. So on behalf of WRC, I propose a well-deserved vote of thanks and request the member to carry out with a loud applause. Thank you, Mohit.
Thank you. Thank you.
Yeah, Lalit sir, shall we start, or you want to?
Yes.
Wait?
We can start.
We can start. Okay. Welcome members to the third session on the topic of forms of legal entities and its registration process, and with the various authorities. This will be taken as by CA Lalit. May I have the opportunity to introduce Lalit in a short. CA Lalit is a registered valuer, SFA, and insolvency professional. He is a chartered accountant. He has cleared in the year 2004. He is currently pursuing LLB from Anand College of Law. As far as experience is concerned, he has a vast experience in construction industries. He is responsible for management and administration of his office. He has done RERA consultancy like formation of society, consultation in relative housing society, handled legal cases with RERA authorities and RERA appellate tribunals. As far as industry experience is concerned, he was in industry from October 2006 to April 2014, working as a senior management in industries, where he has carried out various tasks like variance analysis to facilitate budget, project control, project cash flows, etc. He has also done a lot of statutory audit of listed companies as leader and also as an internal, also in the area of internal audit. With this, I present before you CA Lalit ji. Welcome, welcome you. Round of applause.
Thank you, sir.
Take
my screen is visible, sir?
Yeah, it's visible.
Yeah, thank you. First of all, I'm very thankful to the entire WRC team for giving me this opportunity, and heartily congratulations to the WRC team for organizing such an excellent seminar. There were two subjects which is allotted to me. First subject, which was supposed to be taken by Sunil sir, is also transferred to me. So I will start with the opportunity, and then I'll move towards the formation of the society. If you look at the RERA Act, we will briefly discuss the purpose of the Act. The main purpose was to regulate the real estate sector. Before RERA implementation, there were a lot of issues in the real estate sector, as we all know. This sector was not regulated, and because of this, customer used to suffer a lot. So keeping in this mind, this Act was introduced. The second is sale in a transparent and efficient manner, development of the real estate sector, dispute resolution between the allottee and the builder, and the protect the interest of the consumer. So these are the main five purpose for which the RERA was introduced, and due to this, it has given a lot of opportunity to the professional like us. As a chartered accountant, if you will divide our role, it can be divided into two parts. First is the compliance, and then the advisory part. As far as compliance is concerned, it starts with the registration, quarterly return, then Form 5, which is audit we do in the RERA, then the formation of the housing society, and compliance for compliance service to the society, which is post handover by the builder. Advisory part, which is very important, and we are not giving much of the importance, but advisory is a main part, because if you give the proper advisory, then compliance will come to you. Start with the policy formation. So policy formation start from the map preparation. So once the builder buy the land, he has to make the map. Map means the design of the project. So from the design of the project, your involvement gets started. How I will explain you. If you look at from the GST angle, there are two rates which is applicable right now, rather three. Commercial, it is 18%, so net rate is 12%. Then there are two rates for the housing, 1% and 5%. So if your FSI used in the commercial area, it is less than up to 15%, then 5% rate can be applied, keeping in mind the RREP, residential real estate project. Then comes the 80 IB, 3% rule for commercial, and 90 square meter for the housing project, which is for the non-metro city. So when the map is prepared, you have to check whether the FSI is properly allocated to commercial and residential area to get the proper GST deduction and the income tax deduction. Because in 80 IB, you get the zero income tax rate. No doubt you have to pay 18% net, but that 18% net can be claimed in the other project, which is a regular one. In one of my client, due to non-involvement of our firm from the beginning, the FSI used in the commercial space was 3.20%. So because of 0.20, they lose the entire deduction of the Income Tax Act. So from the map preparation stage, you are supposed to involve yourself. Second, environment clearance is also required. You have to guide your client that when the environment clearance is required. Few chartered accountants have started the practice of the environment clearance also, which is very lucrative area, and the clearance is given by the state government from the Gandhinagar only. So as a chartered accountant, you can explore the environment clearance also. Suppose environment clearance is not taken in the initial stage, then at the time of RERA registration, they ask for the application. And even though your RERA has given the approval, but without environment clearance, if you will start the project like construction, there will be heavy penalty. Few of my client has paid those penalties. So environment, GST, income tax, which all start before you apply for the RERA registration. Then advisory part appear before the RERA authority. Appear as a chartered accountant, you can appear up to the appellate tribunal and authority. So this is also a very good part to practice, and for the future to come, there will be a lot of litigation into the RERA area. Documentation, very important part. Documentation, once you get the RERA registration, then your agreement to sell deed has to be as per the format approved by the RERA authority. Client should not receive the amount in excess of 10% of the sales value before execution of the agreement to sell. Recently, RERA has started giving the notices for the cases where the amount received is more than 10% and agreement to sell is not executed. Today only I had one hearing in the afternoon before this seminar. So they are going to levy a penalty, which will be very normal. So post RERA registration, document part is very important. This is only one of the example how documentation to be done. Dispute resolution, society and builder. At the stage of project completion and handover, there are a lot of dispute between the societies and builder. Society said this facility was promised. Builder said no, this was not promised. So as a chartered accountant, your role come into the dispute resolution part also. I have done few resolution and which is very good exercise and you will enjoy. Landowners and development agreement. If landowner is your client, you should guide him how to protect himself and not to fall into the category of the promoter. And by mentioning the proper payment terms and condition, he can protect himself at the time of the RERA dispute also. Development agreement, RERA has specified few clauses which is mandatory in the development agreement. So you should study those and you should guide to your builder, landowner, how to draft the development agreement to make sure that it is as per the RERA requirement. And if landowner is your client, then you have to make sure that you know how he can be secured. Advisory on the housing society, one of the lucrative area. I will explain how to register the housing society in next 30 minutes. Insurance. Insurance is not mandatory right now because there are not much of the product which is available in the market, like insurance for the title of the property, construction insurance. But going forward, this will be mandatory, and at the time of the handover of the society, as a promoter, you are supposed to give those insurance. So once enough product is available in the insurance with insurance companies, all state RERA authority may come out with a guidelines and they will specify how much insurance to be taken for which period to be taken and which document to be handed over at the time of the society handover. Then the society handover process. Society handover process is also a very important part, because when you hand over the society, you have to execute a document that we have paid the entire maintenance amount, an entire documented is handover. There are no complaints which is pending. Society committee has checked the work of the clubhouse, common facilities, area, and they do not have any issue, and they will hand over the society in future, and they will be responsible for the normal repairs and maintenance. Because RERA gives the warranty period of 5 years for the structural defect and not for the day-to-day normal repairs and maintenance, and which is amount to wear and tear. So this advisory part is very important. Then the compliance part, RERA registration. First question which will come to you, whether registration is applicable or not. If your area is located Within a planning area, registration is applicable. If your project is not located within the planning area, registration is not applicable. Government has defined the planning area as all the areas like GIDC, municipal corporation, all the area except the Gram Panchayat. So you have to check whether the permission is given by the Gram Panchayat. Then sometimes the bankers ask for your opinion also that RERA is not applicable. So I have draft few opinion also, and which is submitted to the nationalized bank and the private bank to make sure that RERA registration is not applicable, and this opinion is useful in at the time of approval for the project. So registration, you have to give advisory whether applicable or not applicable. Second, sometimes the question comes about the land area, the different parcel of the land, and you have to advise whether RERA is applicable or not based on the map. Quarterly return, very important part. We have to understand that quarterly return is not only for the purpose of reporting to the RERA authority. This report will be useful to the different authority, and different authority may ask in future for this form 123. First, form 123 may be demanded by the income tax authority for the purpose of the assessment, because in form 1 and 2, form 123 gives the idea about the budgeted cost. So whether budgeted cost taken in form 1, 2, and 3 is taken into the books preparation. If any difference, you have to explain those differences. Second, whatever progress shown in form 1 and 2 in the March month or April, nearer form 1 and 2 is taken into the books of account for the revenue recognition or not. Third, area shown into the form 3 annexation. Let's say area of the project is area of the flat is 85 square meter, then the applicable GST will be 5%. So at the time of assessment, they will ask for all this document. So quarterly return, you have to understand from a broad perspective of all assessment to the other authorities. So whenever you are reporting any form 3, you have to make sure that this data can be demanded by the different authority, and it is quite possible that in the near future there will be integration between the RERA authority and the income tax and GST, and they will not ask for the data, and they will get online all the data. So in last year, one of my client has got the assessment of the income tax, and I submitted the form 123 also. They had asked for the form 123. It was submitted. The things were clear, so that was not an issue for the assessment part. But major difference, you may put yourself into the trouble, because normally the budgeted cost is changed to make sure the profitability is getting adjusted. So don't fall into all these techniques, because nowadays there is a concept of online assessment, so it will be very difficult to explain to the officer who is sitting at a remote location. Quarterly return, the exercise starts from the registration process only, because you have to freeze the budget. So whenever you are putting any budget, you have to make sure that same budget is used into the books of account. No doubt, once the budgeted cost is freezed into the RERA form 3, it is not possible to change. But in books of account, there is a yearly exercise, so you can change the budgeted cost in the books of account for the purpose of revenue recognition, but there has to be explanation which is available to you, so that you can reply at the time of future assessment. Form 5, which is early audit, very important aspect, and we are going to cover into the, I think, in next session, form 5, how to audit. Formation of the housing society, one of the important aspect, and not many chartered accountants are into the practice of the housing society. I will explain the formalities and the basic structure of how to give the consultancy to the housing society. Compliance services to the society. Once you form the society, then builder hand over the entire society. Then society has to maintain the books of account. They have to write the minutes. They have to get their account audited by the cooperative department. TDS rules are applicable. GST is also applicable to the housing societies. I have 2 societies where the GST is applicable. So this work is very less, but there are very few people who are into the practice of this housing society. So registration part I will explain in the next slide. So compliance and advisory both are very broad field, and this is only the few example where we can give our service to the client. If you are into the consultancy of RERA, there are the few act where you are supposed to have basic knowledge. I'm not expecting you to have a expert knowledge, but basic knowledge. Transfer of Property Act, very important aspect, and this rule is applicable in case of transfer of the immovable property from the seller to the buyer. Few aspects like part performance, when the property is getting transferred, when the buyer is getting right, very important. This transfer of property act will be applicable if you are giving consultancy to the landowner for the purpose of recognition of the income tax act of the capital gain. What is the definition of the land? What is the definition of the transfer of property? These are all applicable if you are into the RERA consultancy. Code of Criminal Procedure 1973. Please read the relevant section which is mentioned in the RERA Act and try to understand. Indian Penal Code, very important. Very few section which is applicable, so read those, because the RERA is a civil code. That is the reason I am telling that, Code of Criminal Procedure and IPC you should read. Gujarat Land Revenue Code, very important aspect, and RERA authority has given the notice against few builder for the recovery of the amount payable to the allotee as a land revenue. So how it works, suppose any amount is recoverable from the builder, buyer has to file a claim to the RERA authority stating that this amount is recoverable as a land revenue. So RERA authority will transfer the case to the recovery officer, and recovery officer will initiate the process of recovery. So officer will apply to the collector where the builder is registered. So main business premises is located. Let's say Baroda builder, they will apply to the collector of the Baroda for the recovery. In this land revenue code, there is a procedure mentioned how to recover the amount as a land revenue. So movable property and immovable property of the promoter or the person from whom the land revenue, any amount has recoverable as land revenue can be attached. So there are few exceptions given, like public provident fund insurance amount. Otherwise, all other property, movable and immovable property can be attached. Those property can be sold under auction and the amount can be recovered. Indian Contract Act, applicable. Registration Act. Registration Act is applicable basically for the purpose of the registration of the sale deed and agreement to sell. Indian Evidence Act, applicable because the RERA is a civil code. Comprehensive General Development and Control Regulation. Basically, this is for the purpose of the FSI. And what are the other regulatory mechanism, like submission of regular data to the local authority? Local authority means the municipal corporation. Gujarat Stamp Act, very important aspect. What amount of stamp is payable on the development agreement, sell it. You should know all these things. IBC. If the company, in one of my case, I discussed the live example. Builder is a company and they have not paid the maintenance deposit of 3 CR to the society. Society is also formatted, project is also completed, and people are staying also. So there were two options which was available to us. We can apply to the RERA authority for the recovery as a land revenue. And second option was to go to the IBC. So IBC was not a option which we exercised because there were not much asset which was available with the builder, because there was only one single project first. Second, the cost of the IBC was very heavy and society was not ready to pay those expenses, because as an insolvency professional, they will charge the remuneration plus cost of the giving advertisement in the paper once the application is admitted. So you have to take into consideration all this aspect, and then you have to see which is the best option which is available. So these are all acts which is applicable when you practice as a chartered accountant in the RERA field. This is the minimum list I had given. If any further act, if you feel, you can refer those. Visible, sir? Slide is visible?
Yes, sir, visible.
Yeah, yeah. See, now comes to the various legal entity, formation of the legal entities for the RERA purpose. So we will start. There are two entities which is allowed under the RERA. I'll explain the procedure. Once the promoter complete the project, every promoter has to file the quarter end. Quarter end means end of the project with RERA authority for the purpose of all compliance. Let's say filing of the quarterly return form 5 and completion of the duty of handover of the project. So before you file the QE, the main act which is applicable to the promoter is formation of the legal entity. Legal entity means housing society or AOP or Section 8 company. In the initial stage, Order 13 was given, which was mentioning that as a promoter, you can only form the cooperative housing society. Then Order number 18 was given. And it was mentioned that you can form the Section 8 company. Section 8 company means a non-profitable organization or housing society. This amendment was done because for the formation of the society, you need minimum 10 members. So there are few projects where there is a 9 allottees are there, or 8 people, only 8 units are there. So in that case, it is not possible to form the cooperative housing society. In that case, you have to form only the Section 8 company. So keeping in this mind, this requirement, this option was given. If you look at the RERA, RERA doesn't say about society or Section 8 company or association. Act is not mentioning about anything which is compulsory. But RERA authority has taken into consideration the Gujarat Ownership of Flat Act and RERA Act, and they have made it compulsory that only and only legal entity in the form of cooperative houses society or Section 8 company can be formed. This has been made clarified through the Order number 18. So once you file the quarter end, they will check at the time of filing the quarter end. You have to mention the formation date of the cooperative housing society, and also you have to upload the registration certificate of the cooperative society or Section 8 company, whichever is whichever you have formed. So we'll start with the duties of the promoter. Section 1114E of the RERA Act. It says about the formation of the society or association by the promoter. So this is one of the duty of the promoter to form the society before the handover of the project to the allottee. Then Section 11 of the GOPA Act, which is Gujarat Ownership of Flat Act, it also says that you have to form the cooperative society or company or association. So RERA Act is not mentioning about the formation of the society or Section 8 company, which is compulsory, but RERA has make it mandatory. And AOP is formed by way of getting only the PAN card from the income tax. So it is not a legal structured, or any act is not applicable. So AOP is like a non-registered entity. So it is advisable to form either Section 8 company or cooperative society. Section 8 company is not advisable because once you form the Section 8 company, all the rules and regulation of company is applicable to that particular company, even though it is a non-profit organization. So there will be director, there will be shareholder. Shareholder will be the buyer of the project. So suppose any person is a director in the Section 8 company who is staying in the society and is not involved into the day-to-day activity. And if suppose, let's say return is not filed, annual return is not filed, and if there is a continuous delay on the part of the society, Section 8 company, I would say, then those default will be applicable to his own company also. So he will be affected as a director because there will be single DIN number. So you should not form Section 8 company at any point of time. You should try to avoid. See, RERA will be applicable if the number of units is more than 8. So you will get very lesser case. There will be 9 units, because in case of 10 units, you will be able to form the society. So try to form the cooperative housing society only. There are few queries from the chartered accountant stating that Section 8 company formation is very easy, while the formation of the cooperative housing society is very tough or lengthy, or it is not manageable. I would say the society formation is quite easy compared to the Section 8 company. Maybe when you start the activity of formation in the initial stage as a chartered accountant, you will feel it that this exercise is very lengthy, tough. But once you form one or two society, you will be very comfortable. Duties of buyer also, Section 19(9), which says the duties of the buyer. Every allotee of the apartment, plot or building, as the case may be, shall participate towards the formation of association or society or cooperative society of the allotee or a federation of the same. Also shall did and contain the provision that allotee will cooperate in formation of the association. So all RERA in agreement to sell and sell did. RERA authority at the time of granting the registration, they will make sure that this clause is there for the purpose of the cooperation. One of my client, Amardeep Homes, Vadodara, they have Amardeep Homes is a name of the project, and the promoter was the Amardeep Infra. I forgot the name. They are my client only. They have filed case against the all buyers, Amardeep Homes Association, that they are not cooperating into the formation of the housing society. So this was the first case of Gujarat where promoter has filed a complaint against the buyer. So this complaint number is there, and you can download this judgment from the Gujarat RERA authority website. And RERA authority has given the clear-cut guidelines to the owners that you should cooperate, otherwise we will take the strict actions against you. Promoter has received the completion certificate before due date of the completion of the project, but due to non-cooperation from the side of the buyer, they were not able to form the cooperative society. So ultimately, the order was passed, and they have been given the window to file the quarter end also. A very good judgment you can download from the RERA website. Has discussed agreement to sell and sell it contain the clause. The allotee along with the other allotee of the apartment in the building shall join in forming and registering the society or association or a limited company to be known by such name as the promoter may decide, and for the purpose also from time to time sign and execute the application for registration and or membership and other papers document necessary for the formation and registration of the society or association or limited company, and for becoming a member, including the bylaws of the proposed society, and duly fill in, sign, and return to the promoter within 7 days of the same being forwarded by the promoter to the allotee, so as to enable the promoter to register the common organization of allotee. No objection shall be taken by the allotee if any changes or modification are made in the draft bylaws of the memorandum and or articles of the association as may be required by the register of cooperative society or the register of the company as may be, or any other competent authority. So in our case in Gujarat, we have two options: cooperative society or Section 8 company. So this is also one of the clause which is always mentioned into the agreement to sell and sell deed clause. There are few societies and project where promoter is not getting the cooperation from the allotee for the formation of the society or company. In that case, you can take the reference of section 19, subsection 9, and you can file the complaint with the RERA authority for the purpose of giving clear-cut guidelines and instruction to the allotee to cooperate in the matter. Formation of association of allotee. This is, I was talking about order number 13 and 18. By a company under section 8 or society is allowed transfer of undivided proportionate in the common area and facility in favor of an allotee as per agreement to sell and sell it. In Gujarat, in agreement to sell and sell it, we are mentioning the undivided proportionate, which we call in Gujarati the varade padti jagya. So in Gujarat, there is no system of transfer of separate conveyance deed for the purpose of common facilities and common area. In Maharashtra, there is a system of conveyance deed where there is a transfer takes place by the promoter to the society for the common areas and common facilities. In Gujarat, at the time of execution of the agreement to sell and sell deed, this area is transferred to the society, and in every agreement to sell and sell deed, it is mentioned. So why the legal structure is very important and why the AOP should not be allowed, because in future when the project goes for the redevelopment, this cooperative society or company which is in a legal form, which will be very useful for passing of all the resolution related to the redevelopment. And I will try to explain the benefits of society at a later in the next slide also. Benefit of the society, proper management, because accounts are audited at every year by the cooperative department. They appoint the auditor from the panel of the chartered accountant, or their internal staff also sometimes comes for the audit. Few people are afraid that that audit is very difficult. It's not difficult, very easy audit, and it is very. They are also very simple in checking, so not to worry about on those part. Maintenance amount can be recovered as the land revenue. If any amount of maintenance which is not paid by the buyer to the society, as per section 48 of the Cooperative Society Gujarat Cooperative Act, it can be recovered as the land revenue. So same procedure which was explained earlier for the purpose of land revenue recovery by the RERA authority can be applied by the society also. The procedure is a little bit different. Here you have to go to the cooperative court. There you have to apply that this maintenance is not paid, and they will pass the order, and then the same method you have to follow to go to the collector and then get the order for the auction of the property. Every property, let's say you are owner of the flat in particular premises, you have to get the NOC before selling. Before selling means before you do the sell deed or you transfer the property to the buyer. If that is done, the transaction will be void ab initio. That sale is not a valid sale. So you have seen the procedure where every bank, before the home loan disbursement, they ask for the NOC from the society. So that is by virtue of the section 48 of the Gujarat Cooperative Society Act 1961. Timely audit and annual report, audit every year. Then you have to file the audit report within a 6 month. You have to maintain the minutes book also. Who are the president? Who is the committee member? Any increase, decrease in the maintenance? Any fund to be invested in other bank? Any person who has not paid the maintenance, what are action to be taken? So all these things getting documented in the minutes book also. The minutes books will be same like company only. Another best part, or I would say best also, and some people feel that is a negative part. As per section 71 of the Gujarat Cooperative Society, you have to invest the fund in nationalized bank only. Nationalized bank allowed. Then cooperative bank is also allowed, and then few private bank they have like HDFC and ICICI, which was at a later part by notification. They have mentioned in the notification that fund can be invested in these banks. Latest banks like IDFC, Yes Bank, names are not there into that list. There are few banks like IDFC which is paying the highest interest. They are giving good facility into the current account. But as per the Cooperative Society Act, this is not allowed. Few people are doing that. But when any problem arise or in case of society is not able to recover the FD because that banks may become the go for the insolvency in the future, then committee will be responsible. Few people are saying that we will take the approval of the member in the annual general meeting. That is also not allowed because the approval which you are taking is itself is a not a legal approval. So if you are in a committee member of the society, you should raise a strong objection for the purpose of putting FD in any bank which is not mentioned under the section 71 list. There are few cases where builder himself take the FD that you give me the FD in the next project, I will give you 12%, 13%. That is also not allowed. So please be careful in this kind of investment. Cooperative department may put committee in a trouble. So this is a section 71, which is investment of the fund. I have taken from the act only. You can refer. The fund can be invested in State Bank of India, postal saving banks, in any of the securities specified in section 20 of the Indian Trust, share security bond debenture issued by any other society, not the company. So investment in the debenture of the company or share security mutual fund is not allowed. In a scheduled cooperative bank, it is allowed because it is cooperative to cooperative. In any land and building, if there is a housing service society, it is not allowed. If you want to make any investment as a housing service society, you have to make sure that it is mentioned in the bylaws of the society. In any corporation owned or controlled by the government of Gujarat and other scheduled banks, not covered under clause 1, with the prior approval of the state government, subject to such terms and conditions as may be prescribed in this behalf. In one of my client, they were investing into DCB bank because DCB was giving 8% interest. This is a case of 2018, and we have applied to the registered cooperative society for the purpose of giving the approval. So they have denied the approval, and approval was not given. So we have not invested. So few people will come out with a solution that we will take the approval, but I have not find any case where the approval is given. I discussed with the few people in the department also. They were also saying that we are not giving any approval because once the approval is given, if any problem happen in the future, then that can come to the authority. This is the section 71. You can refer from the act also. I will not cover the section 8 registration because it's chartered accountant. We all are aware how to get the registration. So straight away I will go to the housing society formation. There are few negative part for the formation, like all the document has to be in Gujarati only. So all declaration, application part, all communication is in Gujarati. So bylaws you have to prepare in the Gujarati. I have all the formats readily available with me in Word file. You have to learn how to type the Gujarati. So anybody want, you can. I have mentioned my mobile number in the first slide. So please contact me. I'll give you all the formats which is available. I will explain also what is the importance of format and how to register. Registration is governed by Section 6 and Rule 3. Minimum requirement is 10 member. Few people are saying it is 11. As per the Act, it is 10. And I have registered one society in Vadodara with 10 members. There was a scheme with 10 flats. So we got the registration with 10 member. 11 member Aadhaar card, PAN card, and mobile number. 11 I am mentioning because if the number of people are more than 10, please take 11 because the department insists that there has to be 11 member. Otherwise, you will put a 10 member, they will give the approval also. That is not an issue. 11 member Aadhaar card, PAN card, mobile number. Construction permission, it means Raja Chithi, last legal report. No separate legal report is required like RERA. Whatever report available last, please take it. Submission done at the time of RERA registration is also acceptable. No new legal report is required. NA order compulsory. MEP. 11 member index of sell deed or banakar. Or you can submit the allotment letter also. Allotment letter is also acceptable, but please try to give sell deed and banakar because that will make their task easy. Bylaws declaration and online application. I will explain how to do the online application and this. You have to go to the ifp.gujarat.gov.in website. Register as new investor. You are not investor, but this is the procedure because all government works is done through this website. This website was introduced for the investor in the initial stage. Then now every department of the Gujarat government use this website. So this is the front page of the website where you have to put first name, last name. First name, last name. Out of the 11 people, you have to select the one person as a Mukhya Prayojak, which we call in English main administrator. Let's say Lalit Raithatha, the PAN number of the company, you have to put your personal PAN number, name of the company. In the name of the company, you have to mention, let's say, ABC Cooperative Housing Service Society Limited. This is the proposed name which you are going to propose. Mobile number, personal mobile number of the Lalit Raithatha, email ID, personal email ID of the Lalit Raithatha. You have to mention password, confirm password, submit. Then this window will come. Partnership on the left hand side, you have to select the partnership form or registration of the cooperative society. Application form, proposed name of the society, type of the cooperative society, you have to select the service. Fund deposited towards share capital, you have to mention 1,100 only because there will be 11 applicant. Per applicant, you have to deposit 100 rupees. So 1100. Then address of the society, plot number, TP number, and landmark mentioned so that same will come in your registration certificate also. Address of the society, correspondence address of the main promoter, personal address of the Lalit Raithatha. Then after you enter all this detail, this is only a 2 slide because the next slide I was not able to get the this is the English version of the online form. So list of document, name of the society, full address of the proposed society, name of the society. Society is limited, yes, by share capital. Area of operation Vadodara. Object of the society as per the bylaws. Are promoters of different family? Yes, this is very important. Suppose there is a scheme of 20 flat or 30 flat, and there are 2 flat purchased by one person, one in the name of wife and one in the name of himself. So here 2 people from same family is not allowed to apply. They can become the member at a later stage, but when they are making the application, they should not be part of the applicant, first shareholder, I would say. Total authorized share capital, number of flat into 100. So 59 flat into 100 rupees per share, it is a price. Number of share to the member, 11, because this is the first allotment to the 11 member. Amount of shares, 11 share into 100. Then accumulated as share capital, 1100. Deposited into the bank 1155 because 5 rupees will be the entry fee. 11 member into 5 rupees. So total deposited 115. In case of federal society, in our case, when you are registering any society, service society for the purpose of RERA, it will know because in our case, there will be no federal society. Federal society comes into the scope when at a district level, any society is created. Then the state upper body, let's say Gujarat Cooperative Bank, which becomes the part of the Vadodara District Central Cooperative Bank. So there they become the member of the federal society. In our case, it is always no. Any preliminary expense, always put no. name in correspondent main head promoter. It is myself. I have just for the reference. Details of the language in which the books of accounts of the society will be maintained. Always put English. If you will put Gujarati, you will to maintain the accounts into the Gujarati only. So suppose if you have put the Gujarati and at a later stage you have maintained the books of account in the Gujarati in English, then it is quite possible that person who is coming for the audit from the department, he may compel you to rewrite the books in Gujarati. So put always English. Signature of the 11 people, then name of the person, name of the applicant, occupation service, address, share capital 100, entry fee. So here the total will be 1155. Amount of share, entry fee deposited into the 1155, which we have mentioned in the upper first page of the application. So this is the English application format, which once you will do the data entry on the IFT website, you will be able to save this form into the PDF. Once you enter 11 member details, 10 members, sorry, and the total of both the sides, income and expenditure, once it tally, you will be able to generate this form. You have to get the signature of all the Prayojak or administrator or first shareholder, and you have to apply. You have to submit it to the register. Then this is same application in the Gujarati. You have to prepare also. Same. This was a translated version of the English application, which was submitted online. So here also everything you have to mention in Gujarati. Sign of all the peoples. I will share all these formats with you if anybody wants. So same 1155. Then this is very important aspect, Petaniyam, which we in company it is called Memorandum and Article of Association. Standard format. Basically, this contain the provision of the committee, that society will be run by the committee. Then what is the petty cash which can be maintained? What will be the share capital? Share વેચાણથી ઊભું કરેલ ભંડોળ 6300 થી વધુ ન હોવું જોઈએ. It means there are 63 shareholders, 63 unit into the 100 rupees. Then where account can be opened, how the account will be prepared, where the books funding of the society, where it can be kept, how to maintain the membership. In case of death, who will be the next person who get the rights of the shareholder, how to maintain the annual general meeting, how to do the election. Karyavahak Samiti, it means committee, what is their authority, how they will manage the society. It is like Memorandum and Article of Association. This is a standard format which I have submitted to Ahmedabad Infused Society. Then it is submitted in Surendranagar, Junagadh, Porbandar, Vadodara. Almost 5-10 cities I have submitted. So I have not received any query till date. Basically, suppose you are located at Ahmedabad, you have to go to the Ahmedabad, Vadodara Sahkari Sanstha. In Ahmedabad Sahkari Sanstha, they have the ready-made stationery which is available. They are charging for it, so you can collect from there also. But due to the higher number of society, we have developed internally, and this is as per the act and approved format. So this also you have to submit. Once you save that PDF, you will get the next slide on the right hand side of the online IFD website. There you have to upload all this signed document. So one is this application in Gujarati, then Petaniyam. Then one will be the English application also, which is a translated version of the Gujarati. Then this is Praman Patro. This is basically a minutes book, initial minutes book for the purpose of the registration of the society. There are 11 members, which name to be kept, the main administration detail, account to be open, very important. Suppose you are in Ahmedabad, you have to open the preliminary account with Ahmedabad District Central Cooperative Bank, first account. In Baroda, we opened at the Baroda Central Cooperative Bank. So this is mandated by the Act only, and they will only open the Suchit account, proposed cooperative society account. So first account has to be with the Central Cooperative Bank, the Baroda Central Cooperative Bank, Ahmedabad Central Cooperative Bank, Rajkot Central Cooperative Bank. So once you get the registration certificate, you will be able to open the account with any nationalized bank or other bank of your choice. First account has to be with the cooperative central bank of your district. So this is basically a minutes for the purpose of giving authority to open the account. There the authority is also given to the 3 people for the purpose of the authorized signatory. This one copy should be uploaded in the website of the IFP, which will be checked by the cooperative society department, and this minutes has to be submitted to the bank. Bank will process based on this. So once you go to the bank for the opening of the account, you have to give this a minute signed by the 11 member and 3 people who are the authorized signatory. Here the name and sign. Then you have to give the PAN card, Aadhaar card, 2 copy, original and Xerox, and photo, 3 photo of the 3 authorized signatory. They will open your proposed bank account. I'll show the format of proposed bank account if possible. And this is a project report, very simple. That this building is constructed through this Raja Chitti, and due to non-availability of any other structure, we are applying for the registration of the society, and this society will be used for the purpose of common maintenance of the facilities. So this is called project report. પ્રમાણ પત્રો સૂચિત મંડળીમાં જોડાયેલા તમામ પ્રયોજકો અલગ અલગ કુટુંબના છે. It was mentioned in the application also, they are from the different family. So here you have to mention that they are from the different family. They are not involved in any kind of the other formation also. Plus, all the documents we have submitted is true. Then another declaration that nobody is involved into the 11 people. You are giving this certificate for 11 people, which will be signed by the main administrator, that nobody is involved in any kind of the criminal activity. Then name of all the people, which signed, photo, address, and the list of the all shareholder. This is normally we give in 3 this thing, 3 copy. I think we have discussed this. Then once you apply, this is the joint declaration. The people from the cooperative department, after scrutiny of the application, they will visit the society, and people who are available at the society, on test check basis, they will check few people that whether you applied for this registration and whether you are in conformity with the whatever submission has been done. So it is on procedure by the department only. So this is at a later stage. It is not supposed to be done by the us. Once you submit all this document, this all praman patra, this application should be uploaded in PDF file once you sign with the bank account to the department, and you have to make a one physical copy of the society registration application form and other document in original. You have to submit to the registrar of the district. No fees is payable to the registrar. The entire procedure is free of cost. If any query is there, you will get the online intimation in your login only, and you will get intimation in your mail ID only. If you will submit the application in a proper way, which I had explained you will be able to get through in a single application only. You will not get query if every submission will be in a prescribed manner. The registration time is 30 days, but if everything is proper, you can get the early registration also. Once you get the registration certificate, you have to hold the AGM in next 30 days. So Mukhya Project main administrator will give application to the cooperative registrar that we are going to hold first AGM of our society on this date. So basically this intimation is given for the purpose of their officer present in the meeting, but they are not coming. So as a chartered accountant, you will make the application on behalf of builder only, because this is the responsibility of builder. So in first meeting as a chartered accountant, you have to make sure that in first minute the society registration is taken into the note that our society has registration by this number by this date. We make a note of this. We have read the bylaws and we are ready to follow all these bylaws. Then our new committee. So whatever first 11 people has applied, normally they remain the committee, but it can be changed because 11 people are only shareholder. They are not the committee members. So 11 committee member can be changed at a later stage also. Appointment of president, vice president, secretary, and treasurer. Fifth, regularization of the bank account, because this bank account was open with cooperative bank. It was opened by as a way of proposed only. It was not a legal registered society bank account. So you have to regularize that account. So regularization by way of putting note that we regularize the account of the cooperative society open with the district central bank, and below 3 people are the authorized signatory. Out of 3, 2 will sign. You can change the authorized signatory also compared to who was part of the preliminary application for the purpose of opening of the proposed bank account. So that can be done. But normally try to keep the people who are in the first application, because they have to go to the bank and they have to change the mandate of the operation also. Important aspect, take the authority. Out of 11 people, let's say give authority to 2 people, 3 people, whatever the society structure permit you, to hand over the to take the society common facility areas, maintenance deposit from the builder, so that at a later stage there will not be any dispute on the builder that society was handed over in an improper way. Try to take the copy of resolution for builder also, and it is the duty of the society to give the copy, because how builder will make sure that they have passed the authority in the minutes to the people who are signing the handover document. Because when the builder hand over any society, they make one agreement on the 300 rupees stamp paper and they get the notarized that we have handed over the society. So try to give the reference of minutes book in the handover document also. Then if society want to open any new bank account, please mention the name of the bank. Let's say society proposed to open a new bank account with State Bank of India, XYZ branch, as per the authorized signatory, as per the below details. 5 people authorized, out of 5, 2 will sign. So that also you have to mention. Any other detail like what maintenance amount you want to collect, let's say 500 rupees per month, 100 rupees, 1000 rupees per month, discuss with the society people and put into the minutes. Important aspect, transfer fee. When any person, original allotee, original buyer sell house to the in resale to the another person, share certificate will be transferred from the original buyer to the new buyer. So that time, few societies are collecting maintenance amount. There are different opinion whether the transfer fee can be collected or not, because this is a service society. Department has also given clarification in 1990 or 95, I don't remember the exact date. They have authorized to collect the transfer fee to the tune of 50,000, maximum amount they have mentioned. So try to keep the maintenance transfer fee in the range of 10 to 20,000 rupees, and mention in the minute book that this amount will be collected. So this is the broad structure. Then another aspect, as a chartered accountant, you have to see TDS is applicable to the society. So get the registration. GST, if it is applicable, get the GST registration. GST will be applicable. Suppose your society is very big, like Godrej in the Ahmedabad, where number of flats are huge. Their collection is also more than 20 lakh rupees. They may not be collecting 7,500 rupees per month per flat. That is exempt anyway. But if they are collecting any charge in the name of, let's say, the clubhouse is given for the birthday purpose, garden is given for the purpose of the celebration, and they are collecting, let's say, 500 rupees, 1,000 rupees, any amount they are collecting, GST is applicable, because that collection is over and above the maintenance. So when 7,500 per month per will be exempt when the collection is made for the purpose of meeting the expenditure of the society. Here, if you are collecting anything in the name of clubhouse facilities or garden facility or any other facility, that is not for the purpose of meeting the expenditure of the society. Any linkage is not there, GST will be applicable if your collection is more than 20 lakh rupees. Interest is also a part of the turnover definition. Authority for Advanced Ruling has given judgment in few cases that turnover is interest is a part of the turnover. If you refer to the definition of the in the GST Act, money is not a part of the goods. So money is excluded from the definition of goods. So interest is money only, because interest you received is the money. But there are few decision which is given by the AR. It says that interest is a part of the turnover. So accordingly, you have to take a call. I have one society where because of the interest they are falling into the net of GST. I have taken the opinion of few people also. They are also saying that you have to get the registration. So bigger societies, you have to be very careful. GST will be applicable, because in bigger society they are collecting extra amount in the name of clubhouse or other charges. Any penalty? Yes, GST will be applicable. Let's say maintenance not paid onto the time and you are collecting extra penalty. If your receipt is more than 20 lakh rupees, GST will be applicable. So these are the broad guidelines and methods how you can do the practice into the society. Any question, please let me know. You can note down my mobile number. If you want any format of the society, I'll provide you 8866263000. 8866263000. Any question, please let me know.
Thank you, sir. I think there are no questions till now. But sir, I have one question. Why in Gujarat they are writing service private limited, service limited, cooperative housing society service limited? In Maharashtra, we don't have like that.
Sir, the reason is that this society is created only for the purpose of maintenance of the common facilities. So it is called Cooperative Housing Service Society Limited. Before this concept, there was a concept of, let's say, building name is XYZ. XYZ Cooperative Housing Society Limited. So that time, people used to buy land in the name of society. Then you become the member of that society. You get the house, let's say flat number 101, and you can become the owner by of getting share certificate only. GST stamp duty was not applicable. Then government has introduced a scheme that GST is applicable on this particular share certificate also. So for the purpose of stamp duty, this housing society concept was there. Now they have created the service society only for the purpose of the maintenance, to service the common facility. Also, service society is not allowed to buy any immovable property. If you want to buy any immovable property, you have to mention in the bylaws of the society. First, if you buy immovable property, if you do any project in the name of the service society, the GST will be applicable to the if any house is allotted to the shareholder.
Thank you, sir. We also recognize the presence of our RCM Murtuza Kajwala ji.
Good evening,
Lalit
sir.
Good
Good
evening.
evening, Lalit. Yes.
Yeah.
Uh,
So Lalit has taken the topic of today in a very excellent and efficient manner. And there are no queries I can see from a board. Now I request our RCM sir to propose a well-deserved vote of thanks to our speaker.
Thank you, Vijay Bhai. I think let me first thank you for spending your valuable time joining as coordinator and doing so much work for the ICI, which is selfless service. So Vijay Bhai, really thank you very much. And Lalit ji, I was actually listening into and the manner in which minutely which you explained, like what documents, what supporting, how they are required to be done, and like you explain in detail, if like someone does it properly, then maybe the registration will be received much faster and without any query. And if there are some this thing, then the queries can come. But I think it is well worth saying that like filling up the whole form checklist and all the supporting. And I think the most important thing which comes up from today's session is again that there is so much more here also where we can provide our services. Like on one hand, maybe we are losing work on compliances, but if we get into RERA and these type of activities, there is really a lot of work we can work back with builders, with the cooperative societies, and we can like get a good share of fees as well. So good practice area, I think, and members will be taking note of it, and maybe they will also pick it up as an area of service. So really, thank you, Lalit Bhai, for taking your time, explaining in such detail. And on behalf of WRC, I want to thank you, and I request all the participants to carry it with a loud round of applause. Thank you.
Thank you, sir. Thank you for your kind words, sir. Thank you.
And any queries, if we get, also later on, we'll mail it to you and we'll seek your responses, Lalit.
Yes, sir. Yes, sir. I'll do it, sir.
And to the participants, if you have any queries, you can write to wirc@ici.in, and we'll forward to all the three faculties, whatever is relevant, get their inputs and come back to you. Yes, Vijay Bhai, over to you. You were saying something. Sorry.
Next session is on 26th of that is on Thursday. It is the various topics are titles under section 17, various certificates under RERA, then annual statement of accounts, functions of RERA, etc. So member, don't miss that session also. Most interesting session. Request all to join the sessions also. Yeah, over to Murtuza sir.
Neighbors, thank you. So I think if there is no further questions, we are happy to close the call. Thank you. And I think good series, members should attend and take the benefit of it. Yes, thank you.
Yes, sir. Thank you. Thank you.
This we will end today's session.